Have you informed him? Item, you are appearing in 2 and 3?
Okay.
2 and 3.
2 and 3. Lordship, in the last hearing, it was submitted my the last on 27/6. After that, 2 days has already been given.
So we'll fix it on. You are making a mention on whose behalf?
On behalf of RDB.
We'll have it on 30 August.
But that
30.
should be the last one.
Yes, last. No further adjournment. Huh? Item 30 at the request of item 2 and 3 at the request made by, what is your name?
K. Deka.
K. Deka on behalf of Mr. MS RDB. Then the judge, counsel will be, sorry, petitioner in person submits that several adjournments have been taken, which should be the last one. Accordingly, let the matter be listed on 30/08/2024. Any reply/objection required to be filed by the content is required to be positively filed within this period. Failing which, the court will proceed to hear the matter on the meetings available on record. Whatever you want to file it by before 30. Yes.
Obliged.
Lordship, I'd like to mention one arbitration matter for listing Lordship. It was lastly listed on Lordship 30/11/2022.
All right, have it on 30.
Right.
Give it to the court master. You have a mention memo, you fill up a mention memo, give it to the court master. Yes, who's for the respondent?
Lordship, affidavit has not been filed till date. On 19 July, your Lordship had directed that affidavit
Mr. Bora,
be
what to
filed
do?
within 2
What
weeks.
has happened? There is a development, my lord. There is a positive development, my lord. Government has taken a conscious decision to appoint the Justice Vikram Sharma as an arbitrator. Now, as an arbitrator in this case. Now we have to take a decision, and there is a proposal from the government side, and the other side there is a proposal from Gobineshwar Prasad Singh. So ultimately, when the lordship have to decide whether this among the panel of list from the High Court, the arbitrator had to be as well as the place we have to decide. Now I have checked the net, my lord, that proposal Gobineshwar Prasad Singh, now Justice, Chief Justice of former Chief Justice of Bombay High Court.
Sorry for the interruption, Lordship. If your Lordship kindly takes page number 12 of the arbitration petition, the procedure which had been agreed to as per the contract agreement, it provides that the employer will nominate one arbitrator and the contractor will nominate one arbitrator.
Then that will be.
And they will constitute, and they both will appoint the presiding arbitrator. So our prayer before this honorable court is limited to the extent that since the respondents were not nominating an arbitrator, this honorable court may do so. Now, when the government has already taken the decision that the respondents are proposing a name, then it is between the nominator decided by us, nominated by us and by them, for them to sit and decide who will be the presiding arbitrator.
So where is your application? Where is your notice asking them?
Yes,
to
Lordship.
Final page number 392. This is the 11 pages, paragraph number 14. My petition is
300.
392. But lordship have to see the GCC whether the arbitration clause at page number 120 also.
392.
392. Name has been proposed.
Page 392, para 14, we have proposed.
Now
Mr. Visheshwar Prasad Singh.
Mr. Prasad. The government had decided that Chittaranjan Sharma is the arbiter from the
All right.
So the relief,
So where is the arbitration clause?
page 120, my lord.
Lordship, it has been quoted at page 12 of the petition.
Go to the agreement directly.
Lordship. Page number 58, Lordship. 58 is the particular condition.
No, at page 120.
There is another
That
clause,
is
120.
GCC, Lordship.
PCC, my lord, that's the way it was.
Then
The
where is the
GCC,
arbitration clause?
yes, Lordship. Arbitration clause is at page number 58.
58.
Page 58, bottom clause 45. 45.5. Any dispute not settled amicably and in respect of which the DB's decision, DB here is dispute board. Dispute board's decision, if any, has not become final and binding, shall be finally settled by arbitration. The aggrieved party may approach the Indian Council of Arbitration within 90 days from the date of the decision by DR for settlement of dispute or difference by the sole arbitrator to be appointed by the appropriate authority of the said council. The
That is co-
settlement of dispute by arbitration shall be in accordance with the following provisions. Selection of arbitrators. Each dispute submitted by a party to arbitration shall be heard by a sole arbitrator or an arbitration panel composed of 3 arbitrators in accordance with the following provisions. Where the parties agree that the dispute concerns a technical matter, they may agree to appoint a sole arbitrator. Where the parties do not agree that the dispute concerns a technical matter, the employer and the contractor shall each appoint 1 arbitrator, and these 2 arbitrators shall jointly appoint a 3rd arbitrator who shall chair the arbitration panel. Now, Lordship, in the instant matter, the dispute which has arisen is with regards to variation. The running
First you explain to us what is this clause about?
Lordship, there are two components in this particular clause.
Hmm.
The first component relates to a dispute where the dispute is related to a technical matter. In that case, a sole arbitrator can be appointed.
No, you read clause 45.5.
Yes, Lordship.
You are required to approach the Indian Council of Arbitrators
Lordship, we have done that. An additional affidavit has been filed before this
within
honorable
90
court.
days for settlement of dispute.
Lordship, in 2019 itself, we had approached the Indian Council of Arbitrators, and the Indian Council of Arbitrators has, by way of an email, if your Lordship kindly sees page number 403, Lordship. 403 is the additional affidavit by which we brought on record the email sent by the Indian Council of Arbitration. Page 403. Dear Sir, this is in furtherance to our 21st October 2019 seeking clarification from the
You are
claimant.
reading 403 of what?
Additional affidavit, Lordship.
Filed on 5th of June.
Yes, Lordship.
Yes.
This is in furtherance to our 21st October 2019 seeking clarification from the claimant in regard to clause 45.5 of the contract agreement dated 13th March 2012 that whether the dispute between the parties relates to technical or non-technical matter. It is pertinent to note that according to clause 45.5 of the contract agreement dated 13 March 2012 between the parties, ICA has jurisdiction related to technical disputes only. Further, we note that for non-technical matter, aforesaid clause provides that where the parties do not agree that the dispute concerns a technical matter, both parties shall appoint 1 arbitrator and the 2 arbitrators shall jointly appoint a 3rd arbitrator. Accordingly, the claimant vide its email dated 21/11/2019 has clarified that the dispute between the parties relates to non-technical matter. Consequently, we understand that ICA doesn't have any jurisdiction over the captioned matter and claimant's reference of request for initiation of arbitration for adjudication of its dispute with the respondent cannot be processed further, and hence the matter will be closed with the return of the process fee to the claimant.
So they have expressed
They have
their
expressed
inability,
that
that they don't have the
they don't
jurisdiction.
have jurisdiction.
Now, pursuant to that, government has now decided to appoint your arbitrator. Has he given consent?
That will have to come up after the court approve it.
No, but you'll have to first find out whether he is in a position to proceed with the arbitration. You have, that we can record it that you have provided, and the rest requirement under the provisions of the act.
That will follow. But normal process is that the consent has to be taken from the after the court appointed. The consent has to be taken. If it is used, then
All right.
second consent. Okay.
So we are closing it on this. We are
Appointing, nominating him as
yes, and
Yes,
then
sir.
in terms of the clause, both will
Yes, Lordship.
decide on the umpire.
Yes, Lordship.
Panel.
The presiding arbitrator will be decided by the two of them.
Counsel. You give your name to the court master, it will be included in the order sheet.
Lordship.
Lord will keep my letter in the record, my lord. That particular letter, my lord.
Yes,
Lord,
we
And
keep it on.
copy of the
We'll
letter
give
may
a
be provided.
reference to that.
Lord.
You'll serve her a copy. The petitioner is a joint venture was awarded who participated in a international competitive bid invited by the respondent for procurement of turnkey contract design, supply, installation and commissioning of intake facilities, transmission mains, water treatment plant and reservoir for North Zone, including 5 years operation and maintenance, within bracket contract package number capital C hyphen 01. Stop. The bids were invited by notice dated 28/9/2007. The petitioner participated in the said tender process by submitting its bid and consequently was awarded the letter of acceptance dated 9/3/2012. Stop. Pursuant thereto, a contract agreement was duly executed by and between the petitioner. Stop. After, according to the petitioner, after executing substantial amount of work, an interim payment certificate within bracket IPC number 7 and 9 was raised for release of interim payment in respect of the works executed. Stop. But the said bills raised were not settled by the respondent, and subsequently negative variation order number 1 and 2 was issued by the respondent, revising the contract value from 80,89,39,834 to TO2 rupees 65,56,26, 124.00. after deduction of rupees 7,7058,312 and rupees 40,87,397.20. Stop. Because of the negative variation orders issued by the respondent, disputes arose with the respondent in respect of the state contract work. That I is submitted by the Learned Counsel Commissioner that in terms of the contract, in terms of the contract, clause 45.5 provides for arbitration, provides for disputes and arbitration. Stop. Under the said clause, disputes are initially required to be raised and placed before the dispute board, which is to be constituted by the respondents. Stop. In terms of the said provision, the dispute board was duly constituted, and but the board could not. The board initially constituted could not render its decision within the period of uh, prescribed period of time indicated. Stop. Subsequently, two other dispute boards were constituted, and finally, the third dispute board gave its report rejecting the claims of the board. Stop. Learned Counsel for the petitioner submits that in terms of the arbitration clause as provided for in the contract agreement, in arbitration, resolution of disputes by arbitration can be adopted in respect of two categories of disputes, namely technical and non-technical. So, insofar as technical disputes are concerned, the claimant is required to raise the disputes before the Indian Council of Arbitration. Stop. It is submitted that when the disputes were initially referred to
The disputes were referred to the dispute board. The dispute board gave the finding. Against the finding, we gave our dissatisfaction, notice of dissatisfaction, along with nomination of arbitrator. They did not
then
respond.
who approached the
The ICA was approached by us, the petitioner,
uh,
in 2019 before the matter was referred to the dispute board.
they submitted that the Indian Council of Arbitration was duly approached by the petitioner, which of course was prior to the matter being referred to the dispute board. And finally, by an email dated
21/11/19.
21/11/19, sent to the petitioner by the Indian Council of Arbitration, the council communicated that in view of the provisions of the in view of the terms of the agreement and the tender clauses, only disputes pertaining to technical matters can be taken up for resolution by the council. Stop. In view of the communication received from the claimant, namely the petitioner herein, that the dispute does not concern a technical matter, the council expressed its inability to take up the matter, and the matter was closed with the return of process fee to the claimant, namely the retribution. So, considering that the uh, dispute was not resolved through the dispute board, and the petitioner having submitted its dissatisfaction note, the petitioner invoked the arbitration clause by, where is your notice? By submitting notice dated so and so to the respondents, informing them that Justice Rajeshwar Prasad Singh
Three nine
where is it?
three nine. Yes, Lordship. 392 is the relevant portion where we have nominated the arbitrator.
The solicitors of the claimant inform the respondents their decision to propose the name of Justice Vishweshwar Prasad Singh, within bracket retired, as their nominee arbitrator in terms of clause 45.5 within bracket 1 within bracket B. Stop. The respondents were called upon to appoint their arbitrator. Stop. However, in spite of several communications being issued, the respondents failed to appoint their arbitrator under the same clause, and therefore present arbitration by with the specific prayer for issuing a direction under for exercising its powers under section 11.5 and 11.6 for appointment of an arbitrator, so that the process of dispute resolution as specified under clause 45 of the agreement can be proceeded with. So, notice in the matter was issued. As per Becker's 2/2024. So, subsequently, several opportunities were granted to the respondents to file their response. Today, when the matter is called on board, Mr. S. Boran and counsel representing the respondent placed before the court a communication dated 12th of July 2024, whereby the this is issued by your parent department,
Yes, Department, Lordship.
When department,
whereby the parent department of the respondent number one, namely the Department of Housing and Urban Affairs, Government of Assam, has conveyed its no objection for towards the engagement of Justice Chittaranjan Sharma, within bracket retired, former judge of the Guwahati High Court, as an arbitrator on behalf of the Guwahati Metropolitan Authority. What is it?
Guwahati, Guwahati. Guwahati Metro drinking water and sewage board.
No, but who is the respondent here?
Respondent is GMDA.
CMDA, project is run by CMDA.
Respondent authority. So he submits that since the parent department has conveyed no objection, court may close the arbitration petition by passing appropriate orders, appointing Justice Chittaranjan Sharma, retired, of Judge of the Guwahati High Court, as an arbitrator on behalf of the respondent in terms of the clause 45.5 of the agreement. Learned counsels have been heard. Counsel for the petitioner has also been conveyed with, has been supplied with a copy of this communication placed in before the court. Okay. Stop. Both counsels agreed, and in terms of clause so and so 45.5, each party to the dispute is required to appoint an arbitrator, is required to nominate an arbitrator, and both the arbitrators will then decide and nominate the umpire. And thereupon the matter, and thereupon the disputes will be attempted to be resolved by arbitration in terms of the clauses of the contract. So the disputes, the decision of the arbitrator, majority of the arbitrator, shall be final and binding in terms of the, as is provided in terms of the agreement, clauses of the agreement. So, yeah, having noticed the clause 45.5, which specifies for arbitration cases of a dispute, this court considers it appropriate to extract the relevant portion for the purposes of this petition. So, extract clause 45, page number 58. Which is the clause? Page 45
Yes,
or
page
page
58.
120?
Page 58.
58.
Yes, Lordship.
Page 58, 45.5. 45, you can extract the entire clause of 45. So, here, having noticed the provisions of the contract as extracted above, and also taking into consideration the submissions of the counsel appearing to the parties, that the claimant has already appointed Justice Viseshwar Prasad Singh, retired, as their arbitrator, and the respondents having today placed communication received from the parent department of Housing and Urban Development, so Department of Housing and Urban Affairs, for nominating Justice Chittaranjan Sharma, retired. This court is of the view that under the powers conferred under Section 11(6) Arbitration and Conciliation Act, an effective order is required to be passed for appointment of Justice Chittaranjan Sharma, retired, as an arbitrator nominated by the GMDA respondent number one in terms of the no objection conveyed by the parent department, namely the Department of Housing and Urban Affairs. So, according to Justice Chittaranjan Sharma, retired former judge of the Guwahati High Court is appointed as an arbitrator. To, in terms of clause 45.5 of the arbitration agreement, to act as an arbitrator for the respondent number two in terms of the same provision of the act. Stop. The court also appoints Justice Visheshwar Sharma, Visheshwar Prasad Singh,
Nominated already.
nominated by the petitioner to act as an arbitrator for the claimant. Stop. In terms of the clauses, going to both the learned arbitrators will decide and nominate an umpire, and thereupon the arbitration shall proceed as per the terms of the contract. So both the learned arbitrators will convey their consent as is required under the provisions of the act. So the parties will appear before the tribunal on, give us a date.
Lordship, until and unless the two arbitrators nominate the presiding arbitrator, the tribunal will be
We have to give a date.
in sole arbitrator, that is
No,
possible.
but they will nominate only if you appear. You have to appear and point out.
Consent also required, my lord, that
Consent part or
That- newly appointed, my lord, appointment, they have no conflict of interest in this case also.
That's
That has to be
right. So you give us a time by which you'll have to appear and tell them that please appoint a third arbitrator. How else are you going to proceed?
Lordship,
How will you proceed in the matter?
that is true, Lordship.
You want an arbitrator to be appointed, we have appointed you.
Yes,
Now you have to
Lordship.
go and appear before the
Yes,
tribunal.
Lordship. But the tribunal is incomplete, so
You have
Hmm.
to address this and tell
Then
them
the
that
third
this is the order of the court. Please go ahead and appoint.
or else, Lordship, the petitioner and the respondents may be directed to exchange the details of the arbitrators nominated by them. For example, I will share the details of Honorable Justice Vishweshwar Prasad Singh retired with the respondent, and then they can provide us with the contact
For
details
what purpose?
so that the two we will intimate to the arbitrator whom we have nominated. And as your lordship may deem fit, if your lordship wants to fix a date, any date may be fixed, lordship.
Yes, any Saturday, non-working Saturday. In the month of September.
Uh, the parties will communicate this order to the respective learned arbitrator, who in turn will decide on the umpire. And once such a decision is communicated to the respective parties, the parties will appear before the tribunal in 15 days thereof.
Lordship. If you oblige.
Arbitration petition accordingly stands disposed of. The communication dated so and so is kept as a part of the report.
If you oblige.
Communication dated so and so submitted before the court by the respondent, kept as a part of the report. Yes. Yes.
Also, last time we have filed a contract agreement as asked for by the as an additional affidavit. Law.
You have filed the additional affidavit.
Yeah, yes, sir, with that is contract agreement. Law.
So, what is the prayer here? What do you want?
Lot of the matter is in brief like that. When department failed to appoint the arbitrator within 30 days, then this honorable court appointed arbitrator Colonel Goswami. Lordship. Due to bad health, Colonel Goswami he retired. Thereafter, Mrs. Nayan Sharma was appointed by this honorable court, replacing that. Then she could not able to give an award within 12 months. Then we have both the party extended time 6 months. Even then, they had not able to publish the award. Then honorable this learned district judge has extended the time to the arbitrator for the further 1 year, which learned has no jurisdiction to do it. But then I came to before High Court by the order of the judge one. This is at case number 6 losses. This is for order of this High Court. Then order of this High Court says no, the lower court has no jurisdiction to extend the date. Thereby, the mandate of the that arbitrator was terminated. Hence, we have come before this honorable court for appointment of substitute arbitrator.
आज What do you say, Mr. Chakraborty?
Lordship, a filer affidavit, Lordship, from the contract agreement, Lordship, page 51. Unit section as clause 70 of the GCC, and clause 70 of the GCC says that, Lordship,
Wait,
page 51.
51. 51.
The contract agreements are submitted by the petition. Page 40, it should be page 40. ये कौन सा? 40.
40, 40 Lord.
40, it should be page 40. Lord. The third point, serial number 3 from the top, Lord. 26.
Yes. What is that?
26. Lord. It says that condition 70, arbitration page 1.
No. We are on something else. Some other
Page 40.
page 40 here is something else. What is the clause? Which clause you are referring to?
26. Serial number 20. From the top is the third point.
26.
At page 40, Lordship, the third point from the top.
The original number on the deed is 51 Lordship. Now this is new is 40, but original 51. Can you sir have a look?
Inner page,
51 Lordship.
inner page serial page 51.
51. Old 51.
And the affidavit pagination is page 40.
I don't know. There are 3 page numbers.
Lordship. Thirty-eight, 39, 40. 40. Inner page 51 of the contract act.
It's in the affidavit.
It's in the affidavit.
It is in my affidavit Lordship.
Yes. You're going through your affidavit.
You may allow me to look at it.
51.
Lordship
51.
51 and new 40 Lordship.
Point number 26. The third point from the top.
I have to find it. Sorry.
Dr. May allow me to add. But,
Okay. Point number
third from the top, Lordship, 26.
26. Okay.
26.
Yes.
Condition 70 of the arbitration page 1. That has not been annexed, that clause 70 of the GCC, that this is not.
What does 26 say? This is amendment.
This is the
26 is the amendment, Lordship.
this is clause 70 of the GCC. Says that some serving official So we have mentioned that the panel at page 19 of our affidavit. So anyone from the panel may be allowed. Page 19 of our affidavit.
Yes. What do you say?
Lordship, when earlier two arbitrator was appointed, the same issue was taken before the Honorable Court. Honorable Court has refused to that. Reason being, Lordship, because they have already failed to appoint arbitrator within 30 days. The Supreme Court says data are this says first judgment. This say when they fail to appoint arbitrator, the arbitration agreement is seized. Then ultimately the Honorable Court will appoint arbitrator, Lordship.
Oh, that is all right. Court
Lord-
is appointed once, twice.
Lordship,
Then the time expired.
Lordship.
Now, who was the last arbitrator?
Mrs. Nan Goswami,
He is
Sharma.
Sharma.
still a serving officer.
No,
She's retired.
she's a retired chief engineer.
Both-
The
both were
state
retired.
government, from the
Both were
state
retired.
Both
government.
were retired.
So,
Lordship, one more, Schedule 7th of 1996 Act says,
Lordship, have,
no employee will be appointed as arbitrator in new act.
Lordship, if Lordship has a
Seventh
panel
says-
of retired chief engineer, Lordship will appoint someone from that panel.
Lordship, my application is under section 15(2). That means replace the arbitrator as earlier appointed, not as a new. 15 says,
where is the communication that he has? Has he issued any communication?
Uh,
Nothing.
no, there is no publication regarding which Lordship.
No, you said that she has given up on the arbitration.
She was appointed arbitrator, Lordship.
Uh,
In page number
Then the
6,
term expired.
term expired. And it has been mentioned in the judgment. Both the party extended again 6 months to her. Even then she could not do. Then London district judge extended the term mandate of the arbitrator,
Who-
which
who-
has been turned down by this honorable court.
Who approached the district judge?
District judge, Sir, Lordship, we approached the district judge. He terminated under section 14 should be terminated. The mandate of the arbitrator should be terminated because he has failed to publish the award within 18 months.
What's your judgment?
Lordship,
You're referring to some judgment you said?
Lordship. I'm referring to judgment law.
Have you gone through have you seen the judgment?
Just mandate of the Supreme Court judgment, the Lordship can.
Kindly have it, the second judgment, sir. Second one. This is the page number 19, para 19.
Para 19. Yes.
I have like highlighted actually the word.
So this is for what proposition?
This is called Lordship, and
That their list of arbitrators are not to be considered.
they are talking about their arbitration clause as condition 70.
Hmm.
And for serving arbitrator like that or retired arbitrator, that the court says no. When they failed to appoint their arbitrator within 30 days, no more, nothing, the arbitration is seized. Now the Honorable Court will appoint arbitrator as per 1996 Act. That is seized wordless.
That may be applicable at the initial stage when the section 11 petitions are filed, Lordship.
Second Supreme Court judgment also says like that in the headline, Lordship.
They have not appointed an arbitrator.
They have said they have not Lordship. Then second judgment in headline only, headline, the under section 11.6 when I have come it, then it is depart the original agreement. There are a lot of judgments, Lordship. I can forward also lot of judgments.
We agree. Now, see, you did not have any objections while the earlier officers were appointed.
Lordship, I was always having a observation when that was appointed. Then they approached, they want to appoint department arbitrator. The court did not turn down their request. They appoint as per 11.6 the independent arbitrator as per the list of this one. And moreover, all the time, these lists, it was appointed arbitrator. Colonel Manoj Goswami was also from this list only.
All right. Now, for substitution, have you suggested any name?
I'm requesting Honorable Court to appoint from the list of this one,
From the panel.
from the panel of this Honorable Court.
Which panel can lead?
District Judge नहीं सकता. High Court से judge को नहीं है.
महंगा पड़ेगा.
काम छोटा है.
महंगा पड़ेगा.
Mobile. कोई बात नहीं.
पैनल है आपके पास? पैनल है नहीं.
Can sir, it is in mobile. We can show.
तो कौन?
नहीं district judge नहीं, ये chief engineer है. ये पानी.
मेरा पति को केवल होगा करीब नहीं तो दोबारा रिव्यू में आना पड़ेगा.
कोई बात नहीं, रिव्यू है.
स्टूडेंट में
It is the network.
We'll just take it up. Let him get.
No.
वो पेज पे खबर कीजिए हमने आर्बिट्रेटर का लिस्ट अभी चाहिए तो भेजने के लिए लेके आने के लिए टेलीफोन है ना वहाँ से भेज चाहिए उसको क्या है फिर इनको भेजिए आप इनको क्यों समझा रहे we'll call for the list दूसरा मैटर हाँ
Is there a receipt, madam? Earlier rejected by your lordship, madam. And madam, your lordship may kindly peruse the earlier order passed by your lordship on 25/7, madam. Earlier rejected by your lordship.
Allegation is that, my lord, the petitioner.
And my lord, notice, my lord, regarding service of
it's not maintainable
It is, that is the, but in our case, my lord, this allegation is, it is not maintained, but case diary.
as my lord, as per case diary, my lord, her date of birth is my lord 1/1/2008, and my lord, here incident of kidnapping on 6/7/23. So on that date, age of the victim is 15 years. So my lord, earlier my friend rightly my lord submitted that this petition is not at all maintainable in view of 376.
Perusal of case
but
diary.
it has not been filed as yet
No, my lord, charge sheet not yet filed.
It
My
is
lord, no new ground, my lord, earlier rejected by your lordship, earlier three petitioners, your lordship's rejection order is at
page 21, my lord.
page 19 to
Page
22.
21, paragraph 6. My lord, even no medical report also shows nothing, my lord. The victim, she admit voluntarily. Page 21, paragraph 6.
No, my lord, not voluntarily. 164 statement of the victim is available, and
Yes,
Our-
on the basis of 164, it is recorded. Paragraph 6. is well. In fact, there was a marriage, my lord, child marriage. When a dispute took place, my lord, the father lost the child. This is the case, my lord. In this case, even the Kazi was also arrested.
criminal procedure What about subsection 438?
That is my lord. There is the power. My lord.
Then?
But my case is that, my lord, there was no medical report also shows.
Whatever it may be, but so long
That
the,
is the allegation, my lord.
so long the section is there, you read the section. You read the section. 438. 4.
I think that, right.
And my lord, if he wants to
But
point out the,
if the allegation on the of allegation, but our case.
Why don't you read the section? Read the section.
nothing,
Subsection.
Nothing in this section shall apply to any case involving the arrest of any person
On accusation. The accusation is allegation. So having committed an offense under
had allegation method.
so that's right, allegation, accusation. The accusation. Accusation will have to be proved for you to be finally convicted. So long it is an accusation, it is an allegation.
But it is mayor registering a case method.
my lord, otherwise,
You have filed, you have other remedies. Yeah. For other remedies. But where there is an express bar, unless the under APP submit that this particular section is wrong.
Yes.
Let it be wrong.
no. And my lord, he is submitting on the basis of medical report, and he is saying that, my lord, this is child marriage. So from her 164 statement and medical statement, there is also, my lord, injury marks also, my lord, corroborate the statement of 164. She specifically said how these accused persons, my lord, confined her, kidnapped her. Thereafter, my lord, for about, my lord, 15 days, every day, my lord, the accused person raped her, my lord. All these allegations are there.
APP, have you noticed section
So
438?
yes, yes,
You're not raising objection on that.
on that. Otherwise, because he is submitting, that's why I'm continuing.
But our case, in fact, there was a marriage. So that in any independent witness.
Mr. Counsel,
there-
why don't you understand the mandate of the
Yes,
section? You think about it. You think about it. You take it up some other day.
Yes.
But this is expressly barred.
Yes.
At the request of learned counsel for the stands referred to be on 160 or on 30 30
Is it-
30. The learned APP will call for updated case report.
Yes.
In the meantime. Case diary
On 38, my lord.
30.
Yes.
I'm
Right? What do I?
Okay.
six, six, no? Oh, right.
You have you go through this?
I have seen, sir. I'm requesting for the Lordship, item number 19, the last one, because he is the engineer also, chief engineer, retired secretary to the account. So I want to take this one.
Yes, Mr. Counsel. Heard learned counsel.
Lordship, if I'm retired district judge also can wait.
So I think suggestion 19 appears to be good because he has a technical background.
17, 18 is also there, Lordship.
No, but 19 is an advocate. 19 is also an advocate. We don't know, it says advocate. Heard learned counsel. Right, very good. Praying for substitution. The appointment of a substitute arbitrator as the earlier arbitrator appointment could not deliver the award within a period of 12 months. Of the period specified. So, the what is the nature of the work?
It's the periodical services allotted to the building, sir, existing building.
The petitioner was awarded.
And
Like how
that-
reports paramount that periodical services. But I think there is some engineer and they don't take care of it. So, because of disputes which arose between the petitioner and the sole arbitrator, initially was appointed on 2007 2017. So, the sole arbitrator appointed, however, subsequently resigned because of ill health. And subsequently, this court, in a petition filed on the 11/6 by the petitioner, appointed MS Noyana or Noyan
Noyan, sir, Noyan, sir.
Nine, sir.
Noyan Sharma as the sole arbitrator. The order dated 5/2/2028. What is the arbitration petition number? 13.
It is 30, right, sir?
Arbitration petition number 13 of 2013. Is it 13?
It was not 13, Lord, sir. It is 13 is CRP before this honorable court, civil revision. It was earlier that I did not have.
Okay, don't give the name. No. The said arbitrator appointment, however, did not complete the proceeding. Although the parties had exchanged their pleading, and she failed to uh, publish the award within the period stipulated under the Arbitration and Conciliation Act 1996. So, being agreed, the petitioner filed an application under Section 14 of the Act of 1996 for termination of the arbitrator's mandate. So, but filed an application for terminating the arbitrator's mandate before the district court, Sonitpur. So, the learned district judge Sonitpur, by the order, by an order passed, extended time suo motu suo motu for a further period of 1 year. Stop this order was challenged before this court by the petitioner in
CRP 13 2023.
CRP 13 of
2023.
So, by order dated 24/08/2023, this court interfered with the order passed by the district court and
Terminate the mandate.
leaving the parties to approach the appropriate forum in terms of the Act of 1996. It submitted that pursuant to the orders passed by this court, by the order dated so and so in CRP number so and so, no further appeal has been filed with the respondent. No appeal has been filed. So there are
No appeal.
Mr.
Appeal
Chakraborty,
here.
CDC appearing for the respondent, does not dispute the factual position as submitted before the court by the petitioner in person. So, the petitioner in person and the learned CDC have been heard. It is submitted carefully. There is no dispute on fact that the arbitrators, two arbitrators were appointed by this court, and the first arbitrator resigned because of ill health pursuant to the second internal arbitrator, who, however, failed to publish the award within the period specified under section.
Lordship, one submission regarding a period, Lordship.
Yeah.
The submission is that because the document of the earlier arbitrator with the arbitrator, the registry will call and submit to this new arbitrator, and 6 month time will request for 6 month time only, because they will readily available the document with the new arbitrator.
I didn't get you. Sorry.
Uh,
Tell me.
Lordship, there are two submissions, and that the document with the earlier arbitrators may kindly be sent to the new arbitrator, and kindly give a 6 month to the new arbitrator. Lordship.
Where are the documents are available with whom?
That is with the Mrs. Nan Sharma.
When she's not a party yet.
But the registry can call for. Yeah,
How?
in earlier case, this was such an order. Okay, the Lordship, as the Lordship.
Where is she taken?
Guwahati. She's from Guwahati.
She's what?
Pardon?
She's an
Retired chief engineer.
type.
Her office is somewhere at Ulubari.
When was she appointed?
In about not with me actually.
There is no dispute that on 5/2/2018, when was she appointed?
So,
Order was passed on 5/2/2018.
5
But I said,
2018. So she was.
as
you
per
have-
his petition.
Is the order of her appointment available here?
it is not
Not
with
in the
me,
record.
not this in this record, Lordship. Sir, what I want to submit.
No, see, whatever you want to submit, we'll have to put it in the order. So for being a part of the order, we need.
And that I agree. Sir. My submission is only that when the registrar will intimate to new arbitrator.
Correct. But
Then-
we want to find out when she was appointed so that this 12-month period can be included in the order.
Okay, sir. Then we will.
You furnish it to the court master itself.
uh,
You must be having it in some.
that is that I'll
Furnish it.
I'll furnish.
The appointed on 5/2/2018 by this court. Pursuant thereto, the parties appeared before the sole arbitrator and the proceedings commenced. However, the award as required to be published under section 29A as required to be published within the period specified under section 29A of the Arbitration Constitution Act could not be published, has not been published. So, consequently, term of the tribunal will have to be considered to have been expired as per the mandate. Considered as per the mandate of the such circumstance, the petitioner is before this court filing a fresh petition for appointment of a threat committee under the part of section 7 of the Constitution Act 1990. So, accordingly, having heard the accounts of the part and upon careful consideration, this court considers it appropriate to appoint Sri Manikanto Das as an advocate and also a former chief engineer and secretary to the government of Assam PWD as the arbitrator. Stop. The name of the arbitrator is available in the notification number 29 dated 21st of May 2024, published by the Registrar General, Guwahati High Court. So, in view of this order passed today, the registry will requisition the, the pleadings available, the complete pleading and the relevant documents available with the earlier arbitrator appointed MS Nayan Sharma
And
and transmitted to the newly appointed arbitrator
Lord.
pursuant to this order. Stop. The reports shall be requisitioned within a period of 10 days from the date of this order. Upon the records being transmitted, the parties will appear before the sole arbitrator appointed by the court on August.
no, sir, I will not be here. Earlier to that, Lordship, on 24, 25, or in September, Lordship.
First week of September.
No, after 10 September, Lordship.
No, see, you are the one who will come back again. That period has expired.
No, I never
You
said,
are-
I never said to arbitrator earlier, sir.
No. It is in your interest. So don't
Lordship,
go for a long
Lordship,
date.
one matter is there in Himachal Pradesh, actually, Lordship. And earlier in on Lordship, otherwise on 25th or 24th.
24th is 24th is totally a holiday. Therefore,
Yeah.
I don't know.
Then Lordship, after 10 on 10th or any 11th on 11th of September, Lordship. That is not much more.
11th September.
Okay,
All right,
11th.
11th September.
Obliged, Lord.
Petition dismissed.
Lordship, one more case is there. It will take in next week because I have to.
All right.
Item 6.
Item number 6.
At the request of the petitioner in person. Oh, this is for
I'm for the petition. He is for the
the request of the
respondent.
petitioner in person.
Respondent in person. Lord.
Respondent in matters that's referred to be taken up after in the month of September on a date to be fixed by the registry.
After month of September, Lordship.
In the month of September,
Kindly fix the date, Lordship. It is easy to me. Or the same 11th.
no, 11th it will not come.
Mhm.
All right, then on
Okay.
30, we can have it on 30.
30th September.
No, 30th August.
August.
No, sir. It may be in September, Lordship.
All right,
Whatever. It may be
13 September.
30th September.
13.
1-3.
1-3. Yes, Lordship.
13 September.
Obliged, Lordship.
You furnish the order to the court master.
Lordship. Obliged. Order for बिल्ट हुआ था नैन शर्मा का?
है आपके पास?
हाँ। ये सर बताओ क्या है? सर मैं वहां से जाके फेसबुक जाके आपको भेज दूँ आपको व्हाट्सएप में। नहीं, मैं तो देखता हूँ अभी मिल जाता तो अभी दे देता हूँ। आप 5 मिनट बताइए। पाँच 4:45 नंबर बताओ।
डेट तो मिल के
5/2/18 का है। डेट तो 500, अच्छा इसको तो निकल मिल जाता है ना, हाई का जजमेंट 518 तक मिल जाता है ना नंबर। मिल तो जाएगा, तो बहुत अच्छा बात है। तभी तक एरिया टाइप का
हाँ अभी करें